Jenny, how are you?
Good. Thank you so much for having me.
Yeah, nice to meet you. So Jenny is running for District Court Judge, Position 3. Jenny, what inspired you to run, and tell us a little bit about your background.
So I was born and raised in Spokane, Washington, and I've been a prosecutor for the last 10 years, for over a decade, and I've been involved in all parts of our criminal justice system, working with kids in the juvenile unit. I've worked in major crimes. I've done a murder trial. I've worked with people with behavioral health disorders, including mental health and substance abuse on our civil docket. So I've been through a lot of all parts of our system, essentially. Mm-hmm. And right now I'm supervising our victim advocates and also our general felony unit at the prosecutor's office. Wow. And so what has inspired me to run? It kind of started with my dad, who had always said, I really want to see you someday on the bench. And I always kind of just joked and pushed it aside because I didn't at that time think I had the experience when I first became a prosecutor. Mm-hmm. I didn't have the life experience to really sit on the bench and make those decisions. Mm-hmm. But over the years and with my experience, I have now, I believe, gotten that experience, that life experience, to hopefully be a good and effective judge. And with the passing of my father a couple years ago, that really, made me realize that I needed to follow my heart and my dreams and take a risk and do what I thought I should be doing. Mm-hmm. And that is hopefully making a difference in people's lives by being the face of a fair system, of one of the best mm-hmm. systems in the world.
Right. And so I'm sorry to hear about your dad. The good news is that he may not be alive to see it, but if you are elected, at least you've fulfilled his legacy for you, I suppose. And that's always a good thing, regardless if they're around. So I my heart goes out to you, and I'm sorry to hear that. What kind of cases would you be ruling over in this position? So
the position that I'm running for is district court, and it's going to be an all-county race. It's all-county, but I'm running for the position 3. It's an open seat. Judge Wilson's currently retiring. Mm-hmm. So the district court is essentially, it's like the front porch of our criminal justice system, meaning that we're getting people from all walks of life coming into district court. They're only going to be cases that are face up to 365 or 364 days in jail. So we're looking at low-level offenses such as driving under the influence, third-degree theft. We're dealing with protection orders, domestic violence on the lower level, fourth-degree assault, domestic violence, trespassing in the second degree. Why this is so important, coming from felonies, which is where I'm currently practicing, and I've done the murders, I've done the violent offenses, but the district court is so important because you have such an opportunity to make a difference in people's lives. You get to stop them from essentially going to the basement of the criminal justice system, and hopefully keep them from going further. And also it's essentially the people's court. Again, like I said, you're dealing with all walks of people coming into district court. And you're a face of the system that people hopefully will never see the felony side. Right. So I believe it is a very important position to have, even though you are dealing with lower offenses. I think my experience, having dealt with some of the worst crimes that our society has faced, mm-hmm. and having that perspective, having dealt with children and seen them progress into the felony system, I've been involved in our therapeutic courts. I've been involved in all aspects, like I said earlier, that I think I come to district court with the perspective that I believe is going to be important in making decisions that affect everybody's lives.
Because, my understanding is 364 days or less in jail, meaning a lot of these people will be first-time offenders or, first time getting caught perhaps, but first-time offenders that you can then say, this path doesn't lead anywhere good, and you ought to take a look in the mirror and see, is this really where you want to go?
Yes, and I have practiced in district court as a prosecutor. We do get, people with 15, 20 misdemeanors that come in through the court system as well. You do get the repeat DUIs where they have an alcoholic problem. So you do get the first-time offenders, and you do get the people that have been through the system a lot. But hopefully, district court that we have in Spokane has a lot of resources. I mean, we always need more, right?
Right.
But we do have a lot of therapeutic courts for DUIs, people with alcohol problems. We have veterans court. We have all these therapeutic courts that are really helpful. And like I said earlier, it is the front porch, and you're hopefully trying to keep people from going to the felonies. Some of these people, they do have a lot of criminal history coming in with the misdemeanors, but I believe with the perspective that I have, having worked in the felonies and district court in all aspects and done over 20 plus trials, I bring that perspective. People say I look really young.
I have a baby face too. So
I normally appreciate that compliment, but now I'm running for judge, and people are saying that, I look like I'm 25, which again is super big compliment for a female, but I do carry that experience of being an attorney for over 10, 12 years now.
Right. And it's funny because my wife always tells me, my wife's 12 years older than I am, and she always, I've started to get gray hair, and she says, yes. And I'm like, what? And she goes, now people will think you're my age. I'm like, honey, you look my age. People think I'm older than you are, because she looks really young too. So it's just, it's funny because the baby face sometimes goes against you. So I understand that. So now let's talk about something from your survey. So thank you for filling out the survey. And on question 2 of your survey, we have a statement that says family and parents' rights. In general, parents should have ultimate authority in decisions regarding their children's medical care and education. You responded a 9 almost strongly agree. And you just commented that I am the mother of three little boys. My husband and I know what is best for our children and make decisions based upon their ultimate well-being. The judicial canons, the Ethics Advisory Committee, restrict what judicial candidates may comment on if it might be perceived by a reasonable person as undermining the independence or impartiality of a said position. With that in mind, judges decide cases according to the law and the facts. A judge's role is not to legislate from the bench or to overstep the bounds of its role in the system. And I completely agree with you. I think that it's really important that we're impartial, but it does have to be hard, though, when you see these things from a legislative position that you don't agree with, to sit on that bench and really make decisions that impact people's lives over the long term. And this probably isn't something that you would rule over because you won't be in a family court, but it's holding that impartiality really speaks to, in doing it well, I think really speaks to the maturity of a person and the maturity of a judge too. Because you have those instances where it's questionable. And so how would you rule impartially? And how would you do that in a way that all people are treated equally?
Well, and so we do, as in district court, we do small claims court. We do some civil work as well, not just the criminal cases. I think it's hard to do anything impartially because we all come in with biases. We all come up with life experiences, and we all have, like I said, I'm a mother of 3 little boys, 8, 4, and 2. And I, as a mother, I do believe I know what's best for my children. And so how do I walk in that courtroom and make decisions based on the law? Mm-hmm. Well, I think what it comes down to is, I'm a very staunch believer in our system and democracy and what our forefathers, made for us. Mm-hmm. And, we're coming up on the 4th of July, which it's a very important holiday to myself and to my family. And so I believe in the law. And so what it comes down to is, judicial restraint. What is the role of a judge? What is that going to be? So you have to put aside your personal feelings. You have to recognize, I think the first thing is to have that self-reflection and to know where your biases are. And you need to know and be able to assess biases when they come into the courtroom. You need to know kind of where people are coming from as well. So you need to be able to read people as well. But ultimately it comes down to the law and applying the law as the legislature intended. And so that, I think, one is recognizing where you stand on issues and being able to put those aside so that you can maintain the system the way it was supposed to be.
Right.
And that's make decisions based on the law, judicial restraint. I'm not going in there to legislate from the bench. That's not my job. Having worked in the executive branch as a prosecutor, I've seen what advocacy is in that regard. My job is to step back and protect our system and to protect the law as it is applied.
And there are, and a lot of judges also rely on case law too. So
precedent.
Yeah, precedent's a huge thing in law, because we can look at that and say, okay, this judge ruled this way, and you see this in Roe v. Wade. There was precedent, but then the ruling that overturned that spoke to the precedent that was used in the initial cases, and why the overturning of Roe v. Wade was how that conclusion was abound, basically. Because they felt like there was I forget the legal term because I'm not a legal scholar, but there was a specific way that judges determine the application of the law and the Constitution that wasn't upheld in the prior rulings on Roe v. Wade over time. And so they revisited and they discussed this. And this wasn't something that was done lightly. They used precedent, rule of law, and the Constitution. And there is no constitutional right to abortion. So they said, okay, hey, we recognize this. The Constitution doesn't speak to this, so we're going to pass that issue back to the states. So precedent is huge, right? And it plays a huge part in what you do from the bench. Correct.
And obviously I can't speak to anything with regard to Roe v. Wade.
I was just as an example.
Yeah, exactly. I just, as a judicial candidate, I have to maintain that impartiality, and this will become a state issue. But ultimately, precedent is tradition, as some justices will say. It's part of the Constitution, Article 3 of the Constitution. It provides consistency, which is very important as a judicial candidate. Some people would say there's super precedent versus just precedent, which is interesting. But we do have to follow the law, maintain consistency, and provide so that our democracy is upheld.
Right. Yeah. Because otherwise you have one judge who has bias that leans one way and another judge that has bias that leans another way. And then it's like, well, hold on a second. This is so gray, it doesn't make sense. But when you use precedent to determine, and if you don't agree with the precedent, then it's up to whoever, and correct me if I'm wrong, but it would be then up to whoever is in front of you to then take that to the Supreme Court and have that precedent overruled.
Essentially, yes. Yeah. Essentially, yes.
Okay. So let's move on to question 3 of the survey, and this is regarding worldview and religion. Judeo-Christian values establish a framework of morality that is necessary for our system of limited government to succeed, and you responded to 9. And you quoted, we, therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, in the name and by authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right ought to be, free and independent states, and for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. The Declaration of Independence. And then you stated the judicial canons, the Ethics Advisory Committee restrict what judicial candidates may comment on, and it might be perceived by a reasonable person as undermining the independence and impartiality of said person. But again, this comes back to bias, right? You ought to be allowed as an individual, not from the bench, but as an individual, to express your religious values. You ought to be able to say, I'm a Christian and I believe that that Jesus is Lord, without that having any impact on how you rule from the bench. Because like you said, you're using rule of law, you're using precedent, and you have your code book, which is the law. We have our code book as Christians, which is the Bible, right? And so it's not, the point I'm making here is, as a Christian, when I tell someone, hey, I think that you ought not do X, Y, Z, I'm not telling them because it's because I believe it, but I'm not telling them because that's my law, that's God's law. And I'm just telling them, hey, this is what God says about that. And it's the same thing, I suppose, from the bench, where you can say, okay, I can set that aside for a second because I have the law of the land that has been passed down. And this isn't me saying that I want to do this or want to sentence you in such a way. This is the precedent. This is the law. And in maintaining impartiality, regardless of what I believe on a personal basis, I have to rule in such a way.
Correct. And so the best judges are going to be the ones that, again, can put their biases aside and follow the law and just apply the law. But part of that also comes from you want to be able to elect someone that you're going to trust. And I think, how do you make a decision on who to vote for if everybody's just saying, I'm going to apply the law? Mm-hmm. And so some of the things that I think you need to look at are, experience, history, and who they are as just a person. And so I do think I am steeped in the Catholic faith. I grew up here going to Catholic school. My 3 little boys go to Catholic school and are being taught the Catholic religion. It's very important in our home life. And I do think the Judeo-Christian values have a historical basis in our society, mm-hmm. from the Declaration of Independence to our Constitution. Mm-hmm. Abe Lincoln, talked about espousing these beliefs from the pulpit. Mm-hmm. We have President John Adams talking about how our morals and values and religion are intermixed with all parts mm-hmm. of our Constitution. It is a part of our Constitution, and I'm proud of our Constitution. And I just want the people of Spokane County to know that, who I am as a person is one thing, but ultimately it's going to be based on what the law is and my experience knowing the law and how to practice law that's going to make those decisions on the bench.
Right. And I think you touched on something really important there, and a lot of people don't understand how pivotal God and the Bible were in the sanctioning of the Constitution. A lot of people don't understand how much prayer went into forming the Constitution. They would oftentimes pray for hours before a session started. So they'd pray for 3 hours, then they'd go into session, and then quote unquote nothing would get done because they would be, okay, well, let's sit back and just let's all go back, ponder, and that's why it took so long to form the Constitution.
I did not know that. I did not know that. They used to pray a lot.
So David Barton, he owns or runs rather a 501c3 called Wall Builders, and it's not about immigration. Wall Builders is about our history, and he has a Bible called the Founders Bible. And in this Bible, he has excerpts that point to the historical documentation, written documentation from the Founding Fathers that shows you how they derived certain parts of the Constitution. And the biblical citations, I suppose you could say, of in the Constitution that were derived from the Bible, and conversations that they had while forming the Constitution. Now, not conversations like this, but by mail, by letter, that they would send to each other, because people don't understand. I think we tend to forget, we drive a car. It doesn't take us long to get 75 miles. They were going horse and carriage or horseback, right? So they couldn't just drive to their friend's house and have a conversation about how to form the Constitution. Oftentimes, a lot of these things were done via mail. So David Barton just has a Founder's Bible. I have one. It's fantastic. It really gives you a lot of perspective and just how much God was in the midst of forming of this country, which is something I'm passionate about. And I think that lends to just really one of the things that we suffer in society today is that even the Founding Fathers that weren't Christians, that weren't professing Christians, they weren't atheists. And this is a very common misconception. They were theists. It means that they do believe in a God, just not necessarily the Christian God. But all of them had a background in biblical teaching. So they grew up in Scripture, and everything that came from that point on in their teachings, a lot of times even the theists would look back to the Bible and they would reference it as, they call it the Book of Wisdom or what have you. But the reality is that everything that was founded and all of the teachings back then, when you went through school, were founded in the Bible. Everything. And so a lot of people tend to miss even people who are don't share my faith or don't share our faith. They say, well, that silly book. And it's like, well, our entire silly country was built on that silly book. So if that book's so silly, then I suppose the Constitution's silly. And you would have those that argue it was. But we're the greatest nation that's ever been. So how can you even argue that? We have the longest standing constitution of any other country ever. I think on average, the average age of any other constitution is like 15 years maybe. I need to look this up because I've cited this before. And I, for some reason I have 7, but I know that's a biblical number. And then I have 15. But by far the longest serving constitution of any other nation ever is the United States Constitution. And that tells you something in and of itself. So I'm glad that you touched on that, because the Constitution is such a pivotal part of our society, and Judeo-Christian values is such a pivotal and integrated part of our society that people don't understand. And it's like, why do we just cast down each other and not just say, this is the reality and this is who we are, even if you don't believe it? Just at least acknowledge that it's truth, because you can't mince truth. Truth is truth. But anyway, so all that to say, I'm glad that you recognize that and you're willing to say that, because it is hard to get judges to come and speak with us without just citing, well, I can't say this because of the ethics committee. Well, I can't say this because of the ethics committee. But who are you, right? And you are a person still. You might be a judge, but you're still a person. Mm-hmm. So I do appreciate you taking the time to talk to us and filling out the survey. So with that said, there were a couple of questions that you did say, hey, I can't answer this, which I understand, so we won't touch on those. So I'm going to go to question 6 on the survey, and the judicial survey is real short compared to some of the others. And the statement is, judges should not interpret the federal and state constitutions as living documents, but should use a textualist and originalist approach to interpretation. You responded to 7, and you said, as judges, we should apply the law as it is written and the facts of the case. It is not our job to legislate from the bench. So this is something that's actually quite important, because I'm a tax accountant by trade. So when they passed the CARES Act and they started to give PPP forgiveness, Congress legislated a law that the IRS then interpreted differently than the intent that was in the law. So the IRS were applying that law completely contrary to what the intent was. And in fact, in the second round of PPP loan funding, I think in the Secure Act, and I could be getting these mixed up, the Congress had to go back and clarify and then add another, essentially an amendment to the first round of funding to give clarity. And so when there are laws that are written, and it's difficult to determine the difference between intent, right? Because sometimes when you read a law, it's like, well, what's the intent? And how do you apply that law? How would you, so let's just say a new law, hypothetical, that has not been really ruled on, there's no precedent, and this case would come before you, how do you rule on something that has not really had precedent before?
Well, I mean, that's a really good question, and it would depend on the type of law. I mean, if you're coming before, you're going to have people on both sides arguing the case, mm-hmm. or the law as it is. And so you have what we call rule of lenity. So if there's any ambiguity in the law, mm-hmm. we have to favor the defense, the person whose constitutional liberty is potentially at stake. So is there any ambiguity in the law? You want to read it, I mean, there's such a thing as judicial restraint, judicial activism. These are types of philosophies that different judges have. Mm-hmm. I would prescribe myself more in the middle of the range here. I do believe that we need to rule based on the law as it is written. Mm-hmm. But how do you do that without any context, without any, you look at the legislative history, hopefully the advocates before you are putting forth that, if they're advocating that position as well. Mm-hmm. Because there's not just going to be a law, there's hopefully going to be some legislative history that goes into their intent.
Right.
So that is something you hopefully will be able to look at. And But again, so you're dealing with rule of lenity, you're dealing with the facts of the case, and I would, again, prescribe myself more as a moderate in terms of interpreting that law. I'm not going to be, again, legislating from the bench, but you have to take into context what is going on in the situation, I believe, but you want to stay true to the words of the law. Okay. You have to stay true to the words of the law. But again, it's hard to answer that question without the law in front of me.
I understand what you're saying. So I guess what I'm asking is, there are laws that at some point had no precedent, right? Mm-hmm. So I think you kind of answered it with the rule of lenity, right? Is it what it's called, rule of lenity? So my question was more, if there's no precedent and this law has not really been applied before, and this comes before you, how do you get to that
precedent? That you take the words for what they're supposed to mean. I mean, again, you have.
That's so vague. It's because it could mean something to me. It's completely different to me than to someone else, right?
Well, and so as a practitioner, you go to the Webster's dictionary as to what certain terms mean.
Okay. So I mean, you get really into the weeds of what's the definition of words, and then really trying to decide.
Statutory construction. Yeah, you're looking at where the commas are. I mean, you have to look at how it is written and what the definitional terms are. And if there's no, again, we're looking at if you're dealing with an RCW statute and they have definitions for terms, hopefully written somewhere. If they don't, then you go to the dictionary.
That's what those are for, the definitions of terms. So it's not for me, it's for you, really.
Well, it's for anybody practicing law, so that we know exactly, what does transportation mean in this sort of, context, for this set of laws. So, I mean, hopefully there's more context. I mean, there's not just going to be a standalone law. There's hopefully going to be a section on those laws that you can then bring together. So I know it sounds like a standalone thing, statute, how do you apply it? But there's going to be other parts to it that you
derive meaning from. Has there ever been, and again, I've never studied law, I've never practiced law, not a judge, just a guy asking questions. So has there ever been a case where there's been so much ambiguity that a judge just couldn't rule on it? Have you ever been aware of something like that?
No. I mean, not to my knowledge. Yeah. Judges will usually, you want a judge who can make a decision.
Right. And so in that case it would be, it's a difficult decision, but I have to deal with what I have, essentially, and make the best decision possible, which then sets precedent for future judges.
And also you have the appellate process. You have, if people don't agree with the judge's ruling, they get appealed, and they go through this process of appeal all the way to the Supreme Court of Washington. So we have an appellate unit actually in the prosecutor's office where I work, which is a very, very great appellate unit. And they argue cases in front of the Supreme Court all the time in Washington to argue that the lower courts messed up or that the Superior Court messed up in their ruling or didn't apply it correctly. So there's always all these moving factors that are always taking place behind the scenes too, with briefs being written after judges' decisions have been ruled on. So let's say in district court, I make a decision and one of the sides doesn't agree with me, they can take it up to an appeal to the Superior Court where I currently practice in, to have one of those judges review my decision and overrule it potentially if they don't agree with it. So precedent is what we refer to in case law that has been established by our appeal process as good law, case law that has been affirmed by this appellate courts, Division III and Spokane areas are what we look to for guidance on how to practice.
So what is a brief? Is that when something gets appealed, you then have to substantiate your decision to the higher court? So
not necessarily. So we would have, as a prosecutor, when I was practicing in district court, I didn't agree with one of the decisions the judges made. Mm-hmm. So I wrote a brief to the Superior Court an appellate brief. So it's my legal memorandum as to why this district court judge made a faulty decision. And so then the Superior Court judge will look at my brief, look at the other side as well. Usually you have a defense attorney who is against it because they were ruled favorably on it. So they will respond to that. Then you'll have the Superior Court make a ruling based on what the district court judge did.
So the brief is moved forward by the person appealing?
Yes.
Okay, so the brief moves forward by the person appealing. So in the appeals process then, does the judge that is ruling on the other judge's judgment, do they don't have any contact with that judge, the judge doesn't substantiate, it's just they take the case as it is in the docket almost, or how the ruling was, and they just take all that information along with the brief, and then that judge then hears both arguments from, I'm assuming, the person that is representing the judge or the state in this case.
Yes.
Is the person who then argues for that ruling, and then the defendant would be the one ruling.
Depending on who is appealing.
Who's appealing who?
Yes. I mean, most often the appeals come from, let's say, I've been in numerous trials, so a defendant will always appeal the trial, and so then the defense attorney will represent the defendant and write a brief or a memorandum to appeal the decision from the jury. And so then it will go through the appeals process. But no one represents judges or any of that.
They're representing, because the judge represents the state and enforcing the rule of law in the state.
Well, as a process.
Well, not enforcing it, but ruling upon, let's say. And then there's also attorneys that represent the state that then would represent that ruling, and they could look at it and disagree with the judge, for example, but they would still go to court and either defend or concede or. Well,
because I mean, usually when you're going in front of a judge, you have two different sides, one advocating for one side, one defending. Right. So it's always in their best interest to then, if one's appealing that decision, you want to be defending that because that was helpful to you.
Right.
So then you have those two parties go up and fight it out.
But you as a judge, you don't get to defend your position.
No.
So it would be a representative of the state, or an attorney of the state, essentially, that would defend your position on your behalf, not you specifically, but on behalf of the state, to defend your position because they either agree or disagree with your ruling.
Well, that's what you need is you want a judge who can make a ruling and have a good record as to why they made a ruling. Mm-hmm. So then the parties can use those words as a basis for why the judge made a good decision or why the judge made a bad decision. You have hopefully a judge who will. The record is so important as a judicial officer of the court because that is where you make your defense of your position in court.
So you hear, I hear things like, you hear things like, okay, well, the new DA or the new county prosecutor is going hard after DUIs, right? And so you hear these things, and so I'm just losing my words here. The intent, I guess, or the assumption, let's say assumption is that they are specifically now looking at DUIs for whatever reason a lot harder than they had in the past. So what do you do when a prosecutor takes an issue and they decide that they want to arbitrarily, let's say, prosecute more of these issues and more of these issues? I know you don't get to choose what the prosecutor decides. But when you see a litany of these things coming in front of you and the prosecutor is going for, let's say the most extreme application of the law, how do you stay impartial to that when you have such a hot button issue like a DUI? And I know that, you're going to say you have to stay true to the law and you have to not legislate from the bench. But there are cases where judges will give one person a little bit more of a lenient sentence over another person, maybe a first-time offender over a third-time offender, which I don't think anyone disagrees with. However, how do you stay true to the intent of the law when you have these circumstances?
Well, and so it goes back to the prosecutor is, part of the executive body who can go after whatever crimes they want. Mm-hmm. So as a judge, I'm there to make sure that the system is working the way it should be working, and upholding the law, like you said. Now, I think what you're asking is how do you handle sentencing? What do you look for in sentencing if they're going a lot after these DUIs? So under the Washington, we have standard minimums for certain crimes. So if it's your second or third DUI and you have decided to plead to your third DUI, you're going to go in with mandatory minimums on certain jail time. The judge has no control over that. That's based on the law. Okay. And if that's, hopefully, you have a defense attorney and prosecutor that have worked on this case for a very long time, probably, and have come to this agreement. If it's a trial, it's a different situation. But let's say you have someone that comes in with 3 DUIs and the prosecutor's asking for way over the mandatory minimum, and the defense attorney's asking for just the mandatory minimum, right? How do you then weigh those two different recommendations for sentencing? Well, you're going to look at a number of factors, and you're going to look at where they're victims, deterrence, recidivism, like is there any remorse on the defendant? Is he showing any sort of responsibility? You're going to look at good use of resources for the community. You have so many obligations. You have to think of community safety. You have to think of victim input. I think sometimes in our system, I'm a victim advocate supervisor, so I see that a lot of victims feel lost and forgotten about in the system. You have to make sure the victim rights are upheld as well as defendant rights. There's so many things that you look at, and I think that because of my experience working with, again, major violent offenders as well as juveniles who, don't have parents showing up to their own sentencing. I've sat in court with a 13-year-old who looks behind them and their mother is not there when they're getting carted off, to juvenile detention. I've seen some of the worst parts of our society, and I think just having that wide experience and broad experience in trying to connect with the community and establish relationships and really being involved in the community can set you up to just be able to discern more of what's going on in front of you. But you want to stay consistent. You want to treat people similarly, because you want... Or
similar cases similarly.
Yes, right. Exactly. I'm thinking of the same case with...
Sure, yeah. I got what you said, yeah.
Yes, so there's so many factors to consider, but and the nature of the case.
So you made a point there, and this always is something that you see it in big cases, right? And they say about, well, does the person show remorse, right? And so is that subjective in a way? Now, don't get me wrong. I understand that people, and the reason I ask this, so let me give you an example. My wife handles grief way differently than I do, right? So she's not a crier. When we were we had to put our dog down, I was a mess. I was an absolute mess. I almost didn't do it, and it was the right thing to do, but I almost just couldn't do it. And she was the strong one, and I was in the corner in a heap. And so she would likely show remorse differently than I would in front of the court. And so who's to say that a defendant who is truly who's to say which defendant is truly remorseful over another? Because it's not just about words, right? So people can be trained to say the right things. And people are smart enough to say the right things and are charismatic. Some are charismatic, some are not, some are cold, some are warm. So it just seems like a very subjective... And
it is subjective, but it's not the only thing you ever look at when you're sentencing someone. But also you want to look at, are they... if they're saying the right things, but they then go out and choose to be like, oh, I just fooled that person. Who's really that about? That's going to be on that person eventually. If they haven't learned from their mistakes. But ultimately, it's not going to be just about remorse. You're looking at the whole picture here. But how do you discern whether or not someone is truly remorseful or not? I'm not sure that you do, but you can take into consideration, you can read people. But as a judge, again, you're focused on the law. You don't want to put too much subjectiveness into your sentencing, but you can tell when someone, apologizes to the court, apologizes to the victim, apologizes to the community, maybe has taken action to correct their whatever they've done, gone out and tried to get treatment if they have an alcoholic problem, done something to be proactive and, hopefully not doing this again. Again, we do have mandatory minimums that we have to apply, but I think as a judicial officer, most often you will have people come in on plea agreements where they've recommended the same sentence. It happens very rarely where you're arguing sentencing in front of the court. I mean, it does happen a lot. I mean, I just did one a few weeks ago as a prosecutor. But ultimately, you want a judge that's going to be fair, considering all different circumstances. It's going to be reasonable, going to be taking into consideration a whole bunch of different factors and not just one.
So in a case where, because you talked about earlier, typically the two parties will get together, so the county prosecutor, for example, and the defendant will get together, or their attorney will get together, and they'll discuss sentencing prior to coming into a court and basically come to consensus. How is that possible, I suppose, is what I'm asking, because isn't it your right as the judge and you're granted the power to enforce the sentencing? So why are they even negotiating that? I agree they should argue the cases in front of you, and then you ought to make the decision because that's your position. But why is it that that's how it is, where they negotiate sentencing before they even come in?
Well, I mean, the prosecutor and the defense attorney, they have that relationship where they can work out cases. A prosecutor can take any case to trial that they want. And instead of going to trial, they can say, hey, Mr. Defendant or Mr. or Mrs., let's reduce your charge. I'll reduce your charge if you will, do so many hours of community service. And so then the prosecutor knows their facts. They know the weaknesses of their cases. The defense attorney, again, would hopefully be advocating for their client. They've talked to witnesses. As a judge, that is not your province. You don't go in and talk to witnesses. You don't know the same sort of facts, essentially what's going on in terms of preparing their cases for trial. So they come before the court and they say, Your Honor, we have an agreed sentence. As a judicial officer, I do not have to follow that agreed sentence.
Okay, that was my question.
Yeah, I do not have to follow that, but again, as a judicial officer, I'm protecting the system, protecting the process, protecting the law. So if I find that, I tell the defendant, I tell whoever it would be, hey, I don't have to follow this. Are you still willing to enter into this agreement? And they're like, yes. And then I'll hear from both sides as to why I should follow the plea negotiations, and then I can make that decision.
Got it. Because I guess my thought process was, if perhaps a prosecutor is going too light or has given too much on, like let's say a fourth, fifth DUI, whatever, right? And there's been, they've hit a car and someone's been seriously assaulted, and my thought was, if that comes before you and they've agreed beforehand, and you look at that and go, well, that doesn't seem right.
I can ask questions too, and be like, why did we get here? What is going on?
Right.
Why don't we have this? I mean, these are certain things as a judge. I am making sure that this is...
And you can deny it. You can say...
I can say it. I can deny it. And I can say, I'm not willing to go through with this. You might want to step back and not come forward before me.
And you can do that on both sides, too. You can do that for the defendant, which we've seen before, where it's like, hey, I don't think this defendant's gotten, let's say, maybe they're being hard done by and they haven't been represented correctly by their defense attorney or so on. I've seen instances on like the court TVs or whatever, not like the reality TVs, but the actual court footage where judges have said, hey, you might want to reconsider your defense attorney. And you... Well,
and yes, of course. But hopefully, I mean, part of the court, the judge, you're going to be making rulings a lot prior, hopefully sooner to this plea agreement. So
right.
You're going to be following this case. It's going to be on your docket. I mean, as a district court, you're going to have a lot more cases than you do, hopefully, in Superior Court, because then you're dealing with more felonies. So you hopefully have more slower offenses. But you're going to be having a huge caseload, but you're going to be monitoring what's going on as the cases go forward. You know, is this defense attorney getting discovery? Is this, how many continuances has this person had? Why do they need continuances? Are they getting their witness interviews done? Are they getting ready for trial? Is this person being represented, you know, to the best of their ability? And sometimes, you know, as a judge, you're managing the courtroom, you're managing the system. So it's not going to be the first time you've seen these two before the court. So you hopefully, as a judge, you'll have some control over that prior to that, to making sure that representation is being done, you know, with the way it should be done, with enough advocacy and zealous representation.
Does now, a lot of people say that the court system is so convoluted, it takes so long to get through cases and so on. In your opinion, is there a way that that the court system can be sped up without losing integrity?
So, and again, this has to do with access to justice. As a judge, you want to make sure that everybody has access to justice. That's one of, I think, the most important roles of a judicial officer, is to make pathways for people to get justice, right? So, yes, it seems convoluted, but and that's what I'm really excited about, is to hopefully try to make ways for people to navigate the system easier without losing its integrity. We currently, I mean, because of COVID, I'm kind of intermixing my job a little bit as a prosecutor, but we've been dealing with backlog. We've been trying to get cases out to trial. So there's been a lot of slow movement on some cases. As a judicial officer, I do believe you can kind of control a little bit the tempo of your courtroom. But, you know, right now I think there's issues with some legal forms not being translated, or they don't have forms for Spanish-speaking people in the community, Russian people. So
Slavic. We have a big Slavic.
Yeah, I mean, Spokane's becoming more diverse as the days go by. And so we really need to accommodate that as well, because we're seeing a lot of those communities being impacted the most. So we need to be able to have forms that have their, you know, languages. Also, I think probation's an arm of the court, so they help enforce the court's ruling if they're put on probation, right? So we want to make sure we have resources for people that are exiting the criminal justice system to be able to have a smooth reentry into the community, or get the help they need so they're not back before this court. So by it being convoluted, you don't want to lose the integrity. You want to be efficient too as a judge. You don't want to spend 4 hours doing a plea when you have 50 pleas that day, but you also want to give it the attention it deserves, so that, you know, everybody, I mean, I think as a judge, it's so important that your voice, your words may be the last words a person hears before their life is changed forever. And even on a DUI, I mean, a conviction is a conviction. And it changes people's lives. It changes how they may have issues applying for jobs if they have a conviction on their record. So just knowing the ramifications, knowing how important it is for that person before you, you want to make sure that that person feels heard, that person feels like their case was taken seriously, but also you need to be efficient. So I think balancing all those different factors is going to be important to that access to justice and the integrity of the system, and keeping it moving, and also being aware of the courtroom and being aware of what's going on in court. Is this person on the 15th continuance because their defense attorney isn't doing their job? Is this prosecutor not is this prosecutor handing over all the discovery, doing what they're supposed to be doing? Are the rules of evidence being followed in court, in trial? I mean, that's why I think as a judicial officer with my experience in trial, I think that's so important, knowing the rules of evidence. A lot of district court attorneys are newer attorneys too, so being able to know the law is so important. Obviously, as a judge, you want someone who knows the law, but you also want them to know how to apply it. Right? You can know the law, but you want someone who's applied it, and that's kind of hopefully where I can fill hopefully a gap.
For them to be able to prosecute fairly, in not just in that case, but in future cases too. And I guess when I said convoluted, I was really touching on continuance, because it seems like there are a lot of cases that it's continued, and that in and of itself takes resources, because they come before the court, and then these take 10 minutes, 15 minutes of your time, and it's like, okay, another continuance. And then they do this, like you said, 15 times. It's like, that's 15 times 15.
Well,
right?
And so there's tons of reasons, right, for continuances, because you have to protect the defendant's right to a fair trial, right? Mm-hmm. So in their process. So we want to make sure that the defense attorney is ready to go for trial. So when the defense attorney gets up there and says, I'm not ready, well, I think as a judge, and this is your 5th continuance, tell me why you're not ready. Tell me why you need more time. Maybe set another hearing to do a status conference with that particular case to make sure that that person has met a deadline that maybe they don't. I know as a prosecutor and as a defense attorney, we carry a caseload. Each prosecutor that I oversee carries a caseload over 100 cases, approximately. 100 cases.
At any given time?
At any given time, yeah, wow. 100 cases. Defense attorneys have caseload standards, but it is a lot. So maybe setting deadlines. Some people work better with deadlines. So maybe really, and then we also have, though, the prosecutor and the victim. Again, victims who have been hurt really badly have to wait for justice potentially. So we have to figure out victims' rights and play. And again, you're managing that courtroom. So yeah, if someone's been on warrant status, meaning they failed to appear for court, that's a separate issue. So the case obviously has to get continued. But again, I think we also have to understand the workload that defense attorneys and prosecutors are under, and they can't take every case to trial. So let's maybe have more hearings. It's a fine balance, because you don't want more hearings to just clog up the system.
Right.
But I think you need to find those cases that are dragging and address them and figure out why. Mm-hmm. Because there are other prosecutors, defense attorneys that are working day in and day out. I always used to say the taxpayers got a really good deal with me because I would come into work at 10 o'clock. I was pregnant. I was staying till 10 o'clock at night. My husband was not too happy because I'd have to walk to my car late at night. But, we're working so hard to try to bring justice to the community. So I think judges need to understand the workload the prosecutors, defense attorneys are under, also the rights of the defendant, and also the rights of the victim and the community to get justice. Right. So again, it all goes to balance, also goes to holding people accountable in court and putting those questions forward as to why do you need another one? Tell me why haven't you done this? Really holding them accountable to their cases.
To the defendant or to the victim.
Yes,
that is
because defendants and people that are coming from the court, they want this over.
Yeah.
They don't want to prolong this. Mm-hmm. Some defense attorneys is strategic, and so again, as a court, you're managing your courtroom. Mm-hmm. I think a lot of people think, as a judicial officer, you're up there applying the law. You're also, again, managing that caseload that's huge, that's coming before you, and you want to be efficient, but also respect the process.
So when you said just now, actually, you said that in some cases for the defense attorney, it's strategy. And so they're basically counting on you to have such a large caseload that you just want to get this case off your caseload.
No, are you speaking to me as a prosecutor or?
I guess, as a prosecutor. So from a prosecutorial standpoint, you said you manage your caseload, you go 10 to 10, you're working 12-hour days. The defendants, or the defendant's attorney, if they're using that, when I hear you say they use that as a strategy, it's almost like, well, I know that they have a massive caseload. I know that they're under stress. And I'm not saying this that in any way violates that you would violate integrity to do this. What I'm saying is there almost a feeling that not necessarily the state defense attorneys, but I think this happens more so, and I could be wrong, more so with private defense attorneys, where they know, and it's like, okay, I know that they're overloaded, I know that the court's backed up, and I know that they want to move along, let's say, some of the quote-unquote easier cases, so let's just play this a little bit, let's wait, and then we can probably get a reduced sentence or something down the line. Does that happen quite a lot?
Well, again, I'm not a defense attorney. I can't speak to that, but I know that as a prosecutor, our cases don't get better the longer they stay. The longer they're pending.
Unless you have a really strong case.
Well, even then, I've had witnesses pass away. Or witnesses become so disillusioned with the system, they get upset, they don't want to be involved in the process. Again, so the defense attorney will be a zealous advocate in any way they can, obviously within the confines of the law and being, upfront with the court. I mean, if they're not ready to go, they're not ready to go. I mean, I have to, but
sometimes it's not that they're not ready to go, it's that they...
Or they're, yeah, I mean...
I'm just asking a question.
No,
I'm just really genuinely curious.
No, I know, and I can't speak to defense attorneys because I'm not one, but...
Right.
I obviously
but
can't
deal with them every day. So
I do, and they're really good at what they do. And again, like I said, a prosecutor has every right to call ready and try to push the defense to trial. So it's never on the defense attorney.
True.
As a prosecutor, you can allow those continuances. So if you're a prosecutor that's going to allow a whole bunch of continuances, and then at the last minute be like, well, shoot, my witnesses, are gone. I mean, who is that really on?
Yeah, that's true. All right. Well, thank you so much for coming and speaking with us. Can you just let people know where to get in contact with you if you have any questions? Just let them know how to get in contact with you.
Well, I just want to thank you for the opportunity to speak with everyone today. As a judicial officer, again, I'm limited in what I can and can't answer, so I can appear impartial so that I am impartial, and that people have confidence in me to be impartial in front of the court. And the people that come before me. I have a Facebook page, Jenny Zappone for Judge. I also have a website, zapponeforjudge.com. You can find me there and find more about my experience and where I come from. There's a phone number as well on the zapponeforjudge.com website that you can reach me at as well. I really hope and I appreciate your vote come November, I think it's 8th. I'm not sure when the actual date.
August 2nd is the primary.
I'm not going to be in the primary.
You're not in the primary. So it would be
November
2nd, I believe. Oh, no, you're right. It is November 8th, I think. I don't have it in front of me.
Yeah, I don't have any. Anyway, I would appreciate your vote, and I just want you to know that I will work my hardest to do a good job for Spokane County, and that I am proud to be from here, and I want to make everybody else proud as well.
So zapponeforjudge.com. Thanks.